we did also touch upon, which was related to royalties. So maybe if you want to elaborate a little on the royalties as well.
Sure, absolutely, Vaishali. Now, other thing that I was talking about, a lot of companies have brand name usage, various type of royalty arrangements for which they pay royalties from India to overseas. Let's take a very simple example to say that, the withholding tax applies. Usually, let's say again, under the tax treaties, the rate will be 10%. The Indian domestic tax law also had a 10% rate so far. Couple of years ago, what used to happen is that there was still a requirement for the foreign companies to file a return, even though a withholding tax has been applied on a royalty or a technical services fees. But you still had to report that income and file an income tax return herein. That seemed like a unnecessary compliance burden to a lot of people, and that was a matter of representation. And the government 2 years ago actually heard it and changed the law to say that if you have a withholding tax due and it has been deducted appropriately, then we exempt you from filing of tax return in India. And they specified that only if you have this kind of an income. Of course, if you have something more, you have a permanent establishment, etc., then this exception doesn't apply. But a lot of foreign taxpayers benefited from this amendment because the withholding taxes were applied and that was the end of story for them. They didn't have to do any further filing. Now, in this year's Finance Act, much to everyone's surprise, this was not spoken about so clearly by the finance minister in the budget speech. At the time of the final Finance Act, before it got announced, in all the amendments, etc., this was just slipped in. And it's such a wide change, which basically says that, firstly, they have increased the Indian domestic withholding tax rate on royalties and technical services fees from 10 to 20%. Therefore, by consequence, what this means is you will now need to resort to the tax treaty benefit. You can still avail of the beneficial 10% rate or 15% as the case may be. But the moment you apply a tax treaty benefit, there is again a requirement for you to file a tax return in India. Basically, what we are saying is that a lot of those foreign companies will now have to again come back to this compliance burden. And when it comes to taking a tax treaty benefit, there are a lot of associated aspects to be considered, such as whether indeed they are eligible for the tax treaty benefit, getting a tax residency certificate from the home country, a 10F form declaration in India, and so on and so forth. Unfortunately, life is back to that additional compliance burden, and with this additional test of making sure that the tax treaty benefit is indeed in place and the companies have appropriate documentation if it comes up for scrutiny before the Indian tax authorities.
But I think the good part here would be the amount of digitalization which has already been taken up at the statutory front on the Indian side, which kind of makes these compliances, though it is being attracted, but then it will be really simplified because of this whole automation and all.
Absolutely. So, today I think India stands tall and in terms of the tax technology at the revenue department side as well. The electronic filings, they go smooth, permanent account number, applications, etc. A lot of it is happening online. And so clearly the procedure itself is not such a big problem, so to say. But of course, there are associated aspects of potential scrutiny that may happen in future and the questions that you may need to respond to. But yeah, I think it's one of those things that you need to live with that compliance. You're right, Vaishali, that on the technology front, at least we've come a long way from how it used to be dealt with.
And is there anything that we have left out that investors might be keen to know when they are looking at India as a prospective investment opportunity?
One of the things is that, there are a lot of other changes in the Finance Act. There are a lot of opportunities as well, I would say, from the gift city perspective, let's say, for financial services sector companies or even other sector companies who are, let's say, wanting to avail of some of the beneficial instruments that are raised. So they still continue to have certain tax advantages, but I think that's a topic for another time. To sum up, at least in the two topics, broad sections that we've covered in terms of the dividend or the royalties and technical services fees payments, essentially what people need to be mindful of is that they need to consider the appropriate withholding tax rates. For dividend especially, you need to strategize as a group. For example, a lot of companies adopt the approach of withholding at the higher rate to just buy peace of mind, at least on the withholding side, no litigation. And then the foreign company files a return, lodging for a refund, etc. These are some of the strategies which one needs to adopt in terms of their own risk appetite. On the royalties and technical services fees part, again, mindful of the potential return filing requirement that may now apply. This will, of course, is applicable from the financial year that we speak, which is financial year 23-24. So the returns for these are only going to be due next year in 24. So there is time for that, but it's just good to sort of get the house in order and plan in advance. I think other than that, the non-residents need to be watchful of some of the withholding tax benefits that are going to go away on interests which were applicable till 30th June in certain specified cases, and hence look at certain other specific opportunities to plan. Then there is an angel tax provision which is on about the shares which are issued by an Indian company to non-residents, whether the valuation of that is appropriate or not is also now a question which is relevant from a tax point of view, not just foreign exchange regulations. And that's also another area to be watchful for. And we are awaiting the prescription of some valuation norms by the Indian revenue authorities on this front.
Thank you. Thank you. This has been really helpful. And I think this has set a foundation for further conversations where, like, be it angel tax, be it anything else. I think there are a number of things, number of possibilities that we can actually keep discussing. But thank you for today. Whatever you shared today was really, really helpful. And I hope it will help all the non-residents for their investment journey in India.
Thank you so much, Vaishali and EBTC, for having me. And it's a great pleasure to share this.